We used this room earlier today and it was unencumbered. It was quiet and then we didn't hear all the background. Today we got lots of it. So give me a moment. We are back. We have much more to do. I had my best guess was at 2:45 for jail arraignments, which was pretty good, except we have an extra emergency hearing in here. So as much as we can. Not to mention, I see these. In fact, I haven't even really seen them at all. So let's address first People versus Patty A. Mitchell. Is that?
It's J. Patty Mitchell.
Yeah, Patty J. Mitchell.
Yes.
All right, I'm Judge Middleton, charged with 2 counts of uttering and publishing. Let me pull these up. I didn't take my walk to lunch because we had a short lunch. Now, all these were supposed to be in my queue. Here they are. All right, Ms. Mitchell. The allegation is that in October, here we go again, of 2022, October 24th of 2022, that you uttered and published a false or forged or counterfeit check in the city of Three Rivers. It was alleged to be in the amount of $1,650 payable to Patty Mitchell, drawn by Patty Mitchell, and it was false or forged. It's alleged that you also uttered and published another check in the amount of $1,605 made payable to Patty Mitchell. Uttering and publishing is an old statute, very old. In fact, it's so old in the power of the banking lobby, it's punishable by up to 14 years in prison. And you are charged as a 4th habitual offender, which theoretically would make this punishable by up to life in prison for a 3-year-old forged check. Uttering a check is preparing it. Filling out or making a false check is uttering. Publishing it is handing it to somebody for payment. So you're charged with 2 counts of uttering and publishing. 2 different dates, October 23rd and October 25th of 2022, both in the amount of $1,650. The other one, they have the decimal plate in the wrong place. So let's take a look at this.
I don't understand the forging. It was my check.
Well, I'm just reading you what the charge is.
Oh.
All right. Yeah, this is a common thing. People would put in a check and make a deposit, and then they would take money out of the ATM machines before the check's cleared. And here's the way it is written. Mitchell will come into the bank on, none of this matches, on 10/24 and 10/25. She came into the bank and deposited a check for $1,650 on an account she had at the Bank of America. She came out the next day and deposited another check from the Bank of America for another $1,650. She then proceeded to go to various ATMs and pull the money out of the account. Both checks then turned as account closed checks. So they have a video of you. Apparently you anyway, that's the allegation. So let's get up to speed here. How did you come to get arrested?
I was driving in Sturgis and I was going 30 or 40 and a 35.
So you got pulled over for speeding and they found these old warrants?
Yes. I will have to say though, that back when this happened.
Ms.
I
Mitchell,
received a
please
letter
don't
from-
discuss any facts of the
Oh.
case. That's something to discuss with your attorney.
Okay.
That's why Ms. Yancey is here or Ms. Harden, to make sure that your rights are protected. So they apparently didn't look for you or they couldn't find you, and this warrant's been hanging out since February of 23. So it's coming up on 3 years old. All right. Are you on probation or parole anywhere?
No,
Where do you live?
in Edwardsburg, I've lived in the same family house for 36 years.
So they apparently didn't look very hard.
So,
It's the US 12 address in Edwardsburg.
yes,
All right. Okay, I'm going to appoint an attorney and set a pre-exam conference for, they didn't tell me what dates to use.
I believe we're looking
Oh,
at
here they did,
11.
November 18th. 30. And preliminary examination if needed for 11/25. 25 at 1 o'clock. Not on probation or parole. They allege some old previous felony convictions. These are 2 paper transactions. They would total about $3,300.
the majority of
Say that again.
I don't know if I can say it or not. The
If it has
majority
to
of
do with the facts of the
paid.
case, I would just advise you speak to
All right,
counsel.
I'm gonna just set bond at $2,500 PR.
Thank you.
You can go out to the jail and pick her up. On your promise that you will return for your pre-exam. They're going to give you some paperwork with a lawyer's name and number on it. I want you to call that number and make an appointment to discuss it with your lawyer prior to November 18th.
I will.
I'm giving you a PR bond. It's a property case. It's 3 years old. You never moved. Nobody ever made a much of an effort to serve this. All right. So you've got family here that's going to come out to the jail in a little bit and pick you up. And I will see you here at the courthouse where I am, right here in Centerville, on November 18th. That's a Tuesday at 8:30 in the morning. You're going to call your lawyer appointment to discuss this with them. Apparently the bank's out $3,300 no matter what. So one of the things they're going to be asking for here is restitution. That may be something you may prepare yourself for. But now you're presumed to be innocent. I'm going to set bond in the amount of $2,500 PR. I don't need any specific bond conditions. But there are some that are common. You can't leave the state of Michigan.
And then tell me what you want.
You can't get in other trouble.
Can
Bond is $2,500 PR. It'll take a little bit to do that order. Shana, you can come ahead and pick this one up. I would say perhaps by 3:30 or 3:45, they'll be ready to be picked up. All right, Miss Mitchell, I don't know what the deal is. We're gonna have to sort this out. And we'll see what we got. Thank you.
Thank you.
All right, good to go. Thank you for your patience.
Thank you.
I'll give you some advice before you go.
Yes.
Hi, booking. Could I see Thomas Papke next? All right, thank you. Bye. Out by the jail is Yoder's. May you stop there and get a donut, make the trip worthwhile. And you could even stop there and get something to eat at the deli counter after you pick her up from the jail. Take her to Yoder's and get a sandwich or something.
Thank you.
All right. All right. All right. Now I'm gonna do this waiver of an extradition, Jordan, while you're here. Then I've got this civil matter. And then then we're gonna have to come back to these. What I have left, and I haven't even looked at them very well. Carl Lockhart, domestic assault, resisting and obstructing assault of pregnant individual. Joshua Summy, driving suspended and no insurance. Not sure why that's in here. Brett Rose, parental kidnapping. Sanford Haley, assault with intent to do great bodily harm, fourth offender felony. So we'll take a look at those. Let me bring these people in. Someone's in as Zoom user. Is that you, Miss Otel?
Yeah.
Yes, that's me.
I put a search. I'll get you. We're gonna find the return of 3,000. Oh, really? Okay.
That room is so noisy. Very good. Would a breakout room help? Mr. Bouchard is here.
It might not. I actually would like to try to speak with my client again. I haven't been able to speak to her since.
All right, why don't you go in the breakout room, the Zoom room, I'll bring it up. I've got Gina Fitch here. Which case are you here on?
Miss Eddles.
All right, very good. Mr. Bouchard, I'm going to put Ms. Yancey in a room with her client for a moment.
Okay.
And I'm also doing criminal arraignments in the middle of this.
Understood.
But we'll do the best we can. So thanks for your patience.
Not a problem, Judge. Thank you.
Jordan, we may be able to do some more while they're negotiating. I'm gonna put you in what's called a breakout room where you can speak privately with your lawyer. So when the button comes up that says join, you join, okay?
Okay.
And I'll be here working on some other stuff. All right, for the rest of you, you can watch me do some criminal arraignments. Good afternoon once again, Mr. Papke. I saw you this morning on that traffic matter. I tried to see you early to get you on your way, and then I learned that there's a waiver of extradition that needs to be executed. So let me make a note here. We discussed the fact that you were wanted in Indiana, but I didn't know the details. I know more about it now.
Now, can you or will your pivotal person get the surgeon to make sure that he's completed?
Boy, that's annoying. Mr. Papke, you're wanted in the state of Indiana for violating the terms of parole. I told you it was a hold from Indiana Department of Corrections. They would like you to come back to Indiana to address those matters. I took care of your traffic case this morning. This is asking you to go back to the state of Indiana to address your matters there. What county is this from?
LaGrange County.
Aaron Smith, born in 90.
Here's what the waiver of extradition language says. I, Thomas Scott Papke, am the person wanted by Hendricks County, Indiana.
Hendricks.
I don't know where that is.
No, I don't want to plead nothing like that. I want to say LaGrange County.
All right, so you don't wish to, I don't even know where Hendricks County is. You believe you're wanted in LaGrange County?
I got a hold. I'm on parole. I got out of Westville and I never reported. And I know I got a case that's pending. It's a PPO violation. It's an invasion of privacy is what they call it down there out of LaGrange.
All right, well, this is for Hendricks County. Are you willing to waive extradition to Hendricks County?
No, not for Hendricks, but LaGrange I will. I don't know what Hendricks is.
It's Plainwell, Indiana, but Plainwell, Indiana is in Hendricks County. I Googled it, if I'm being honest.
Plainwell, Indiana.
It's a prison.
Oh, it's the prison. Plainfield?
I thought
I went to
It's
Westville.
Plainfield.
It's a prison?
Yeah.
So I don't understand. Am I going for prison or I've never been to Plainville.
This is for prison. It's for violation of your parole where you
Okay.
never appeared on your sentence. So they've issued a bench warrant for your arrest. And they want you to come back.
I did my sentence. I just never reported for my parole.
Parole. Okay. Well, that's what this is about.
So it's in Plainville? It's not Westville?
It's Plainfield, Indiana, I believe Hendricks County. So if you don't wish to waive extradition, problem is it'll be dead time, but that's up to you.
I'll waive it. I'll waive it.
All right, well, let me read the language. I, Thomas Papke, am the person wanted by Hendricks County, Indiana, on a pending warrant charging the offense of violating the terms of parole. I hereby waive the issuance of a Michigan governor's warrant and other procedures incidental to extradition proceedings, including the right to an attorney unless I have already retained one. I voluntarily agree to return to the demanding state in the custody of an agent of that state, which would be the state of Indiana. Are you agreeable to that?
Okay, yeah.
All right, I'm going to send this order out there and you can sign it.
So Hendricks County is Plainville? It's not Westville.
Not Westville, Plainfield, I think is what it is. Not Westville.
All right.
It looks like Westville's in LaPorte County and yeah. Plainfield's in. Hendricks County.
All right, I'll send this out to the jail. You can sign it, then you won't be sitting there doing dead time. You'll get back to Indiana and figure out what you gotta do. Maybe they'll just get you. All right.
Seriously.
Good luck, Mr. Patke.
All right, so am I signing that now?
Yeah, you're good to go.
You're right.
All right, let's see, Jordan, who else I can see. Let's talk to Joshua Summy. He's on few waiver. He's got some traffic tickets to deal with. All right, can we see Joshua Summy next? Summy. All right, thank you. Bye. Figuring this out as we go. I want to take a minute on these to the more serious charges. This is a charge of no insurance and driving suspended. These are under state statute. I think the thing to might get him in here for a pretrial with the prosecutor on Wednesday morning and address those, do them tomorrow because we're just super swamped.
Do you have a file number for that, Judge? I can't find him on the.
25239 SM and 2240 SM.
Thank you.
Good afternoon, Mr. Summy. This is Judge Middleton. I'm here. Also present is Jordan Harden from the Public Defender Office. They brought me these files this afternoon. You got 2 outstanding tickets from just a couple days ago. You got charged with no insurance under the insurance code. That's a misdemeanor, punishable by up to a year in jail and a fine of up to $500, not less than $200. You're also charged with driving with a suspended license. That was November 1st, same day. Driving suspended is a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. You got picked up on a fugitive warrant from another jurisdiction. Where's your fugitive warrant from?
Noble County, Indiana.
They didn't want to try to do a waiver of extradition until they took care of these tickets. My suggestion, Mr. Summy, is you plead not guilty to these and I'll set it for a pretrial on Wednesday morning with the prosecutor.
Okay. Does that mean I can go to Noble County and take care of that before?
That's why I'd like to do this on Wednesday. We have to take care of these before you can go. No, you got to stay till we do this. Set prosecutor pretrial for 11/5 at 8:30. Try to resolve these. You can't bond out because there's a hold on you, but I'm going to put $100 cash or surety bond per file. They'll bring you over here to the courthouse on Wednesday morning. You can meet with the prosecutor and see if we can take care of these so you can go to Indiana and take care of your other matters. So I'll see you here at the courthouse on Wednesday morning. I'm the only judge here this week, so it'll be me that you see. All right, thank you, sir.
Thank you, sir.
All right, that's 3 down so far, Jordan. That's not bad. The other ones I want to take a closer look at. They said both of these could wait. I guess I can do Brett Rose. Tab already set the bond at $7,500. Hi, could we see Brett Rose next? Thanks. Bye. Oh, we're doing all right. Do you have the file number on this one?
I do, thank you.
252028FY.
Yeah.
I'm sorry, Judge, did you call my name?
No, Mr. Butchar, we're still waiting for them. I'm still trying to knock out these criminal arraignments.
My apologies. I was focused on something else. I
Well,
thought I
don't need to apologize. I'm sorry for the wait, but right now we're only 13 minutes behind. It could be a lot worse.
all good. Yep.
All
no
right.
problem. Thanks.
Thanks. Miss Cousineau and Miss Fitch get to watch our criminal arraignments.
Hello.
Hi,
Hello, sir. How are you?
I'm good. Are you Brett Rose?
Yes, sir, I am. Or yes,
All right, my name is Judge Middleton. I'm here to get your case on track. Also present with me is Jordan Harden from the prosecuting attorneys, from the public defender office. Mr. Rose, you got charged with parental kidnapping and interference, and I want to get your case on track. The magistrate set bond at $7,500, but I'm going to put some conditions on it. I'm going to appoint an attorney for you.
Okay.
I'm going to appoint an attorney and set a pre-exam conference for November 18th at 8:30. And a preliminary examination if needed for November 25th at 1. Now, the bond was set by the magistrate at $7,500, cash or surety.
Yes.
Do you live in Palm Bay, Florida?
Yes, sir, I do.
I'll tell you what the allegation is. I just talked to somebody from Palm Cove. I'm not sure where Palm Bay is. Where's Palm Bay, Florida?
Palm Bay, Florida is, oh man. It's Central Wise, Florida,
What county is it in?
Brevard County, so.
All right. The allegation is that on August 28th, you did take or retain for more than 24 hours your child with the intent to detain or conceal that child from the other parent who had custody or parenting time rights. This is a very weird statute. It's punishable by up to a year and 1 day in jail, which makes it a felony. Because it is a felony, you're entitled to have a preliminary examination and pre-exam conference. So I'm going to put some bond conditions on here. The allegation is you took your kids for the summer and they were supposed to return for the school year and you failed to return them, so the prosecutor charged you with this felony offense. It is a condition of your bond that you do not leave the state of Michigan without permission of the court. You do not commit any crime while on release if you do post a bond. You're to provide your email and telephone number upon release if you do post the bond, and immediately notify the court in writing of any change of address.
Yes, sir.
I'm supposed to sign this somewhere and they'll tell me where. All right, $7,500 cash or surety bond. Pre-exam conference is November 18th at 8:30. I will see you at that time. No,
Did I not give you a second page?
no.
Okay, I'll run and I will get that for you. Sorry. Can I give you, this is for Mr. Summy. Can you sign right there? And then that's for Rose.
Yes. All right, Mr. Rose, you're good to go. I'll see you on
Yes, sir.
November 18th. I used to have hair that same color, so that's good. You're good to go.
Oh, right.
Meg, how are we doing?
I think we're okay. I emailed final terms to Attorney Butcher. I have not seen a response from him, but.
Mr. Butchart, I think we're ready to address your case. Stick with me, Jordan. We're doing all right.
I'm reviewing that email right. Give me
All right.
When they started. There's only thing I walked in. That's what I told me when I walked in, but yeah, I thought.
That room is so noisy.
Okay, Judge, I think I'm good to go.
All right.
Oh, are you changing Mr. Rose's bond?
No,
Okay, then I don't think you have to sign. It's already said.
there's Mr. Summy. I'm on hold for a little bit. I'll call you when I need my next customer, but let's leave the room open for now. All right, thank you. Bye.
Do you want me to see
That was the other page of Summy, I thought.
anything else?
Not ready yet.
All right, perfect. Thanks, Judge.
All right. Well, everything says criminal arraignments, but it's not. There's a lot of stuff missing from this file, but let me call it. This is entitled Village Manor versus Felicia Hotel. The file number is 251496 LT.
Good afternoon, Your Honor.
Chart is here on behalf of plaintiff, their manager. And Felicia Hotel tenant also present. I'm not sure why, is Gina Fitch. This was a non-payment of rent case, and I don't have the whole file in front of me. Just a portion of it. So let me get into the file. The court entered an order that the defendant had to pay rent or move. Let's look at the judgment. Was ordered on August 25th after a hearing that the defendant had to pay $1,642.50 by Thursday, September 4th, or be subject to being evicted. So after that, the defendant started sending me letters, which I couldn't really act. They kept emailing or calling, and so I would forward each of those emails to counsel. And was trying to get rid of eviction. Fortunately, Meg Bauer filed an appearance on behalf of the defendant from legal aid and filed proper motions. Well, the defendant filed a pro per motion, emergency ex parte motion to quash the writ of eviction. She contends that the manager has refused to and keeps refusing payment. She claims that she refused a $4,000 total payment. Now, on a termination of tenancy action, the landlord does not have to accept payment. In a non-payment of rent case, the defendant has an absolute right to redeem and maintain the tenancy. So Meg Bauer is here for the defendant. The defendant is here by Zoom, and Brian Butchart is here on behalf of the company. So Ms. Bauer, I'll defer to you first, since it's the defendant's motion to stay the eviction.
Thank you, Your Honor. This case landed on my desk Friday afternoon, but the basis for legal aid's involvement is that the 56 days from the date of the judgment was October 20th, and the writ was issued subsequent to that. There's also the new landlord-tenant law regarding source of income, prohibitions on discrimination through sources of income, but I believe the parties have reached resolution in this matter, and that is what matters the most. So at this time, the parties have agreed, at least my understanding, is that in contemplation of Ms. Edel's tenancy continuing, being able to continue, that her being allowed to redeem, the defense or Ms. Fitch will procure a cashier's check or other form of certified funds drawn to the order of Village Manor.
Now, Ms. Fitch is connected with who?
Ms. Fitch is a family, my understanding is that Ms. Fitch is a family friend of Ms. Edel, and the two of them have privately arranged for a personal loan of sorts. So my understanding being this is not income that needs to be accounted for and create a recertification headache for Village Manor, but I have spoken with Ms. Fitch, and she has represented to me that she is prepared to issue a cashier's check. She was prepared to do it today, but I was unable to follow up with her as we were finalizing exact numbers. So I would actually like to inquire of Ms. Fitch on the record if that is still her intent. But what Mr. Butchard and I had discussed was a very short adjournment.
Well, let's talk about what the numbers are.
We have agreed to $2,273.81, representing the balances on the account through November, rent through the end of the month, and charges accrued November 3rd. And
That's correct, Your Honor. That includes court charges as well from the underlying judgment from back in August.
Ms. Cousineau, are you cup now?
I'm still Cousineau.
All right, she referred to as Lori Cup, so I wasn't sure if we were talking about. The defendant contends she attempted to make payment and it was declined. Mr. Butchart, what do you know about that?
Your Honor, it's my understanding that CAA had presented my client with a document asking for signature. At that time, CAA was proposing to pay an amount that was not sufficient to satisfy the arrearage, and on that document, they were asking my client to agree to forego any eviction rights for a period of 30 days when my client wasn't being assured that the full redemption wasn't even going to be made. So they did decline to sign that document. They have not refused tender of any money.
All right, well, Ms. Otel, this money came with strings, allegedly. I told you at the hearing that you had to pay the entire amount. Partial payment of the rent will not cure the right to get a writ of eviction. So if Community Action Agency gave you $1,500 to give to the landlord, they have to take it. However, if they give you $1,500 and give it to the landlord and tell the landlord you have to forego some of your rights or forego other amount of rent, they don't have to do that. So if it's an absolute tender of payment, They have to take it. If it comes with strings attached, it does not. And this goes under the category of no good deed goes unpunished. The landlord attempts to work with the defendant for 56 days. They don't get the matter clinched within 56 days. They don't get the writ. Then defendant says, too late, 56 days have expired. You got to start all over again, which would induce landlords not to agree to work with anybody for 56 days, but just pursue their writ. So,
Judge, may I?
yes.
Perhaps, I think this is actually just a matter of miscommunication between the parties. One person saying, I have the money, somebody else saying, I don't want to give the money if you're going to be evicted. The other side saying, well, I don't have the money in hand. And I think with Mr. Butchert and I, we've been able to just bridge that. We do have some denials from Community Action Agency within the redemption window based on the landlords not participating, but I don't think we need to litigate this. I think the parties want the tenancy to continue. Landlord wants to be made whole. Tenant wants to make the landlord whole. And I think Mr. Butchert and I have been able to.
All right, those are worthy goals. Ms. Bauer did mention the change in the law. At one time, the landlord did not have to choose to participate in the funding programs. They don't have that option now. If an agency or a federal department is willing to pay the rent, they have to accept it. And so it looks like we're going to get squared away. Ms. Fitch, are you prepared to issue a cashier's check in the amount of $2,273.81?
Yes, sir.
All right, I'm going to grant the temporary stay. We'll continue this. Monday, November 10th. 2:30. If the rent is paid, we don't need to have a hearing. If it isn't, we can further discuss the stay and the writ of eviction. So that agreeable to you, Mr. Butchart?
It is, Your Honor. I mean, it sounds like we're going to receive the payment. And obviously, if that occurs, then Ms. Bauer and I will draft some documentation so we can get this off the court's docket before the 10th.
Very good. Ms. Bauer, anything else we should put on the record?
No, Your Honor, just that I appreciate the collaboration with my colleagues.
All right. Mr. Butchart, you probably see this too. After the date passed for the writ,
So I asked you.
logged in at 7:30 and I've been on it ever since. So it kicked me off
Okay.
8 hours later. So I'm not sure if they're on daylight savings time or Eastern Standard Time, but anyway, I had to relog in. Where the tenant, implores the court to not allow the writ of eviction to enter. And we don't do it by email, and she did finally file a motion. So it looks like between the work of the parties, you guys have come to a solution. I appreciate it. All right, Ms. Otel, this will get your rent paid through November. I implore you to comply with all the other terms of your lease. Your rent is going to be due on December 1st. They're not posturing this, so it's an income to you that would require recertification. But I'll adjourn this matter till next Monday, and hopefully I won't have to hear any more about it, because the money will be paid and the case will be resolved. Thank you all. Mr. Bouchard, thanks for doing this on short notice. I set this like Thursday afternoon or something for hearing this morning, hearing today. So thank you for your help too.
No problem. We much prefer the quicker resolutions, Judge. So thank you.
All right, thank you. I hope this is paid and you guys are all good to go. All right, thank you.
Thank you, Your Honor. Take care.
Thank you.
Thank you, Judge. I know you're done with me, but you're not done for the day.
I got more to do with Jordan. All right, thank you. I'll remove this Fitch. There she's gone. I'll resume the Zoom room. I don't think I'm gonna need it anymore. All right, let me take a look at what the heck I got here. I haven't vetted any of these, looked at any background. Give me a minute. I'll dial up Mr. Haley. Hi, Sergeant Balk. This is me, Judge Middleton, still hanging in here. Could I see Sanford Haley? We got the room open. All right, thank you. Oh, bye. Fred Sanford Haley. All right, let me get to what I need to do here. Mr. Haley, I'll be with you in a minute.
Okay.
I'll move as fast as I used to.
Yeah, that's.
Mr. Haley, this is Judge Middleton. We've met. Also here is Jordan Harden from the Public Defender's Office. You got arrested over the weekend for assault and intent to do great bodily harm less than murder by strangulation. It's alleged that on 6/16 in the village of Burr Oak that you attempted or did assault Crystal Haley by strangulation or suffocation. That is a felony. It's punishable by up to 10 years imprisonment and a fine of up to $5,000. Count 2 is domestic assault that alleged that at that same date and place, you made an assault upon Crystal Allen, someone you had a dating relationship with. That's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Then they allege that you did interfere with a crime report. That usually has to do by taking a telephone or preventing them from reporting a crime. That's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000 and could be consecutive. You're charged as a fourth habitual offender. The allegation is that
Six, but I think you guys already could have done is. But, then they said,
there had been some assaultive issues and they couldn't find you. She claimed that you put your hands around her neck and cut off her ear so she could not breathe. And then she said she bit you. So anyway, they weren't able to find you. So the officer submitted it for a warrant on June 18th. The prosecutor authorized it on October 23rd. And the warrant issued. And in the meantime, you got arrested. Let me ask a couple of questions. When did you get arrested?
Last night.
Where at?
At my mom's house, 204 Second
Which
Street.
is where? Which is where?
It's in Sturgis.
You're not living with Miss Allen?
Yes.
Oh, she lives there too?
She's in Athens right now, but we've been together since that happened. Supposed to happen because I never did do that to her. But she accused me.
Mr. Haley, I would advise you from making comments about the allegations until you talk to your counsel.
Okay.
But you and Miss Allen have been living together since June?
Yeah. I was only away from her for one day.
All right, so I don't like these when it takes months to get authorized and then the parties are back together. So where is Miss Allen now? At your mother's house?
She's probably delivering mail. But yes, she is.
But she lives at your mother's house?
Yes.
Which is where?
204 Second Street, Sturgis, Michigan.
How did they come to arrest you? Did they come to the house specifically to arrest you?
All I know last night is when I was home, I was in bed, and they came about, I don't know, about 8:30 and just knocked on the door and asked my mom if they could speak to me, and my mom said,
hallelujah, somebody tried to serve a warrant. I don't have a criminal history in here. If I'd had more lead time, I would have asked for one. There should be one in here, but there isn't. All right, so they came to the house to serve the warrant. Was she there at that time?
Yes.
Are you employed?
Yes, I am.
Where's that?
I work at Professional Climbers for Mark Poley.
All right. All right, these are serious charges, assault with intent to commit great bodily harm as a fourth habitual offender. You have several previous methamphetamine convictions. Delivery of meth in 2016, 161758 was the district court number. Another one, 161868FY, and another one, 191659. My recollection, Mr. Haley, were you in the drug court treatment program?
Yes, sir, it was.
Successfully completed it?
I completed the program, yes.
Good for you. I'm not going to do a PR bond because it's an assault with intent to commit great bodily harm, but I'm not going to set it terribly high because you didn't go anywhere. In fact, the complainant moved back in with you after the incident, and you've been together since June. It got submitted. I don't know when the prosecutor submitted it, but the officer signed it on October 23rd. It was filed on, the authorized complaint was filed October 23rd. So the officer's signature says it was submitted in June. Can't tell whether that's accurate or not, but anyway, it took a while to get this done. So the bond is $2,500 cash or surety. You shall personally appear for any and all hearing, trial, arraignment, or any other court proceeding. You shall abide by any judgment entered in this case and surrender or serve the sentence if such a sentence is imposed. You're not to leave the state of Michigan. Do not commit any crime if you do post this bond. Provide email and telephone number upon release immediately to the court. And if you change your address, you immediately need to inform the court in writing. Do not use alcohol or any controlled substance. Do not purchase or possess a firearm. Do not harass, intimidate, molest, wound, threaten, or engage in any conduct that would cause Crystal Allen to be threatened. And you shall not have any contact with Crystal Allen. Now, this is a difficult condition because if you get out, either she's going to have to move out or you're going to have to stay somewhere else. But you're not to have any contact pending the disposition in this matter. I'm going to appoint an attorney. Set pre-exam for November 18th. We're going to be busy that day at 8:30. Preliminary examination if needed for November 11/25, 25 at 1 o'clock. Bond is $2,500 cash or surety. with conditions. No assaultive or threatening behavior, no contact with Crystal Allen, no drugs or alcohol. I'm not sure if that's still an issue or not. I hope it's not. You shall not use or possess a firearm. I'm not going to order community corrections supervision because the parties have been together for 6 months, but I'm not doing a PR bond either. If you post the bond, you're going to give the attorney's name and number, and I want you to call that attorney and make an appointment to discuss this with him prior to November 18th. If you don't post the bond, the attorney will come out to the jail and see you then. Do you have any holds anywhere?
No,
And you're not on probation or parole?
nope.
That's what I thought. All right, Mr. Haley, I'll see you either way on November 18th.
Okay.
All
Thank
right,
you.
you're good to go.
Thank you, Honor.
All right, Shayna, one more down. All right, Jordan, let's see who's next. Carl Lockhart.
And so the court is aware I do represent him on 2 other open cases that are set for sentencing next month.
All right. Again, I haven't a chance to vet these or look at anything. What do you represent him on?
He pled to a couple reduced felony charges, and he was set for sentencing earlier last month. But there was an issue with the PSI, so Judge Pattison agreed to a reset so that could be completed.
Let me take a look at those.
They seem to be similar charges, though.
Good afternoon, sir. Are you Carl David Lockhart?
Yes, Your Honor, I am.
Well, you're the wrong. Yeah, you're gonna.
Mr. Lockhart, this is file number 252241. I'm Judge Middleton. I think we met before. Judge Pattison is dealing with your cases, but let me take a look at something. Also here with us is your lawyer, Jordan Harden, who represents you on some other matters. She's here today in the capacity of a public defender. Looks like most of your cases have been Judge Pattison.
Yes, Your Honor.
All right, let's talk about this case. The allegation in the case that we're dealing with right now, file number 252241, alleges that on or about yesterday, November 2nd, you assaulted Lisa Ann Klusterman, who was pregnant.
Yes, sir.
As a second offense. That's alleged to be a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. The other charge is resisting and obstructing a police officer alleged that you did a resist or obstruct Nathan Ritchie of the Three Rivers Police Department.
Yeah, that's new to me, Your Honor.
Mr. Lockhart,
All right,
please
well,
refrain from making any statements.
Here's what the booking sheet says. I was dispatched for a domestic assault. I found the two parties involved near South Main and 4th Street. They were identified as Elista Kusterman and Carl Lockhart. They have been dating for 1 month. Klusterman is 24 weeks pregnant. Lockhart admitted to grabbing Klusterman's face to try to get her to stop walking away from him. Klusterman acknowledged this happened and explained she was trying to get away from when this happened. Lockhart is known to be under the influence of alcohol, is erratic during this interview and threatened to assault Officer Ritchie multiple times. While in the sally port of the jail, Lockport presented multiple indicators he was going to assault Officer Ritchie. He lunged at Ritchie after getting out of the back seat, said he was going to headbutt him. Lockhart proceeded to make assertive movements while in his custody, and the jail deputies came out and subdued him. Klusterman had a bruise on the right side of her face. It is unknown if it's related to this incident. Lockhart also tried to kick out the rear windows of a patrol car while he was been taken into the jail. That's not ideal. Can't tell whether you were drinking or not, absolutely. Now, the other cases, let me get them up here. I apologize. I didn't have enough time to properly investigate all this before I was given these files. Anyway, Mr. Lockhart, the resisting and obstructing charge is a felony, and you're entitled to have a preliminary examination on that case. In file 251367. FY.
That's, I feel like I just get it. So, not trying to get more than you by any means.
It's alleged that on July 15th, you were at Miss Klusterman's apartment and you damaged her window. You were intoxicated. They took you to the hospital. He wanted to get inside and headbutt and kill one of the roommates. So that was set for us.
Miss Klosterman.
Ms. Klusterman was not.
Was.
Mr. Lockhart, please. Ms. Klusterman was not involved in those earlier incidences. This is the first time her name's come up since I've represented Mr. Lockhart.
Well, but I'm trying to see what the status of this one is. Pre-sentence report, defendant pled. I'm not sure when he pled. And it's pending a pre-sentence report in front of Judge Pattison. He was on bond in the 1367 and he got arrested again on 251625. And they had to tase Mr. Lockhart. He was using methamphetamine and alcohol. 251625. Set for sentencing in front of Judge Pattison December 4th. at 10 a.m.
And Your Honor, just so the court is aware, for those other cases, Mr. Lockhart is working with community corrections and is on tether, so he is already being supervised.
All right, that's good, because I'm canceling his bond in both of those cases. Bond in 251367 FY is canceled pending sentence. Bond 251625 FY is canceled pending sentence.
That means I'm staying in jail, Your Honor?
Means you're staying in jail until at least November 4th, when Judge Pattison sees you, when he gets back, if he wants to set a bond. This is the second time you've been arrested for a felony charge while you have been on bond for a felony charge. You're no longer presumed to be innocent. You're no longer entitled to have a bond. Those cases are pending sentence. Because of an issue, they had to continue it. The allegation in this case is you were drunk. You wanted to fight with the cops. You tried to kick the window out of the police car. You allegedly choked this lady in the face. So yeah, you're going to stay right where you are. So doing a jail arraignment, I guess it doesn't matter what the bond here is. Bond is $10,000 cash or surety, because your other bonds are canceled.
Roger that.
Conditions are appear for every court appearance, abide by the judgment entered, do not leave the state of Michigan, do not commit any new crimes if you do post the bond, do not have any contact with
My fiance, my unborn child, 0 chance.
Say that again, I'm not sure I understood.
I'm my fiance, the one I'm getting married to, that is carrying my child. And it kind of just seems like retarded, don't it?
Well, it said you've been dating for a month, but she was 24
Yeah, together.
weeks pregnant.
You just need to get your information a little bit better, as it sounds like.
Yeah, I don't disagree. I'm going to appoint an attorney. Set for a PEC for November 18th at 8:30. Preliminary examination for November 25th, 25 at 1 o'clock. This is a dangerous situation. Something bad's gonna happen. I trust if Judge Pattison was here, he would have done what I just did, which is cancel your bond pending your sentence on these other 2 felonies that were reduced to misdemeanors. So yeah, you're gonna sit from now till December 4th. In the meantime, there will be a pre-exam conference on this new resisting and obstructing charge and allegedly assaulting a pregnant individual. The bond in that is no drugs, no alcohol, no firearms, $10,000 surety, and no
Lockhart,
contact.
please.
Seth Kloosterman. In the meantime, they can continue to perfect the pre-exam or the pre-sentence report. But someone's going to get seriously injured or killed here. We're going to put a big timeout and you're going to sit for a while till Judge Pattison can address this. You'll have an attorney. It may not be Attorney Harden. It may be a new attorney, but they can raise the issue regarding your bond in those other cases. But as I indicated, you were on bond in 251367 when you got arrested on 251625. Now you're on bond pending sentence on both of those when you get arrested on this new felony charge. You always want to headbutt somebody.
Sure do.
All right, you're good to go, sir. I'll see you on November 18th. Thank you, Jordan. I didn't note that it should appoint you. I don't know if you want me to or just let it go through the system.
So it actually was supposed to be my week, but I had to switch. So it's Rhonda's week now. So I will probably be getting some paper in some form or another.
All right, thank you. Thanks for your help, patience.
Thank you. Have a great rest of your day.
It's almost over.
That's a positive. There's only an hour
As
left.
busy as today was, tomorrow is even worse. I have a couple of CSC prelims and some other stuff, so. In for a penny, in for a pound. Nobody made me do